Hi, I'm Harmeet Dhillon, the Assistant Attorney General for Civil Rights at the United States Department of Justice Civil Rights Division. And I wanted to share with all of you an update about our Second Amendment work under Pam Bondi's leadership. The Attorney General works closely with me and others here in the DOJ, as well as folks in the White House, to help expand our Second Amendment rights throughout the United States. And it's personally something that I'm very passionate about, and have been a longtime gun owner and advocate in court for Second Amendment rights. And so let's get right to it. There was a case this last week that was in the news. It was a case that's known by the name of Reese. In this case, a couple of our national gun groups challenged the under 21 sale of weapons by FFLs, and they won. They won an injunction from the district court. And so we at the DOJ decided not to appeal that. And we agreed to work with the plaintiffs to get as broad as possible an injunction consistent with the recent United States Supreme Court decision, Trump versus Casa, in which the court limited the use of these so-called nationwide injunctions. So without being nationwide, we did agree that the ruling would take effect throughout the Fifth Circuit Court of Appeals, in which this district court was, but would also apply to plaintiffs in these groups. And so the district court issued an order last Thursday saying that the gun groups would have to disclose the names of their members in order to have them covered by this injunction. So we didn't agree with that, and of course the plaintiffs didn't like that. And so we agreed and jointly stipulated on Friday last week to go back into court and ask the judge to withdraw that and amend the judge's order. And today the judge did that. And so everyone is happy, and the gun groups are not required to disclose their membership, and a broad as possible injunction with the cooperation of the DOJ is in place. So really excited about that. Some of the affirmative things that we're doing at the DOJ on gun issues include, I went personally to the Seventh Circuit last month to argue a challenge on the amicus side for the United States to Illinois' ban on a number of very popular weapons, including the AR-15, which, as you know, is the most popular rifle in the United States, and which Justice Thomas has written favorably about as presumptively being something that, being a popular weapon used for legitimate purposes by law-abiding citizens, should be considered constitutional. So that's the direction of the court, and that's the direction that we believe compels Illinois' law to be struck down. Then there are other states that have laws like this, and we're filing these amicus briefs around the country. Another example of that is a case called Wolford versus Lopez in Hawaii. Hawaii has a broad public carry ban that would appear to be inconsistent with several Supreme Court precedents. So we have gone into court on an amicus basis there in the Ninth Circuit to challenge that law as well. Really excited about an affirmative case that I brought together with my team here in the Civil Rights Division just 2 weeks ago, where we sued the LA County Sheriff for taking as much as 3 years to process concealed carry permits. Now, under United States Supreme Court case Bruin, it is basically a shall issue regime for law-abiding citizens, and taking 3 years is not really shall issue, is it? And so we are hoping to get that precedent established if we have to go all the way in that case. And that is the case in some other states and municipalities as well. So that's going to be a very important case to watch that could expand people's liberty throughout the United States. We have a Attorney General's Second Amendment task force, which is looking at different things, including beginning a registration process for former nonviolent convicts to be able to resume enjoying their Second Amendment rights. I think this is a really important and very liberty-oriented position that the DOJ is pushing. We're also looking at including suppressors in the scope of the Second Amendment and how to harmonize the case law and regulations with that. We're working with ATF on ATF's review from top to bottom of firearm regulations. And, you know, people have a lot of issues with ATF and how it's administered some of these. There's been some zero tolerance policies by prior administrations, and I think we're going to do a lot better in this administration if folks will give us a chance to, really get rid of some of this old stuff that shouldn't be on the books and harmonize our laws with the constantly evolving precedents. The final point I'm going to make today is there's a case also in the news called Rush versus United States. And in that case, the plaintiffs are appealing or seeking to get certiorari to the United States Supreme Court on National Firearms Act requirements for short-barreled rifles. There's some registration and some taxation requirements in that law. Unfortunately, Supreme Court precedent to date and all of the courts of appeals have not been willing to go so far as to say that short-barreled rifles, whether they're sawn-off or otherwise, are presumptively constitutional. Now, that may be something that could change in the future. It's probably something for people to discuss with Congress, but so far the Supreme Court cases on this issue have held that there are some different characteristics of the short-barreled rifles versus the others that are more commonly used, and they may be more dangerous and so forth. So whether you agree with that or not, it's not really for the DOJ to make that call, but the DOJ's call in this case was our Solicitor General, who's down the hall from me, John Sauer, has opposed cert in that case, holding that there isn't a sufficient ripeness here, there's no circuit split, and the law simply does not support the plaintiff's position in this case. And so these are complicated issues, and I know people are very, very passionate about them. I am too. And so I would ask that folks who are very passionate, interested in these Second Amendment issues, talk to us, talk to Congress, talk to the White House, give us some grace, give us some time to deal with these issues while right now we're in a shutdown and we're still doing so much stuff that is important in matters of public safety. But please trust and believe that this is the most Second Amendment friendly Department of Justice in history. Yes, that's a low bar, yet we managed to rise way above it. I'm proud to be part of that and look forward to hearing from and engaging in dialogue with all of our allies throughout who believe passionately that the Second Amendment is a first-class right in this country. Thank you very much.